fighting a restraining order renewal in Washington state. If you're watching this video, you may just be interested in how restraining orders are renewed, or you may be in the situation where you've lived with a restraining order against you for a year or more, and now you've gotten a notice that the petitioner wants to renew it. What to do? Well, my name is Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. We've been defending people charged with crimes and fighting restraining orders for more than 20 years. And this is a really difficult situation because if you're a respondent and you've had a restraining order against you, you've been obeying, you've been living with the consequences, and you think it's about up, and now you get served with a notice. So in this video, I'm going to cover three things. How does the restraining order renewal process work in Washington state? 2, what are the standards that the court uses? What's the law say about whether or not the restraining order will be renewed? And 3, and most importantly, how do you fight it? What do you do and what do you not do? Because most people make the same mistake, and that is a bad one. So if you find this video helpful, please like, please subscribe at the end. It helps me get the information out there, and I'm going to move right into things. Number 1, restraining order renewals. How does the process work? Well, the petitioner or the protected party in a restraining order, be it a domestic violence protection order, a stalking order, those type of things, a harassment order, they are allowed within a certain period of time, usually a few months, depending on the statute, to petition the court prior to the expiration of the order to have the order renewed. So what's that mean? Well, the petitioner has to go to the court. They have to get a piece of paper from the court, and they have to fill out all the reasons why they think they still need the order, why they're still scared of the respondent, and they can't sleep at night, or they're upset, or whatever it may be. And then they file that with the court prior to the expiration. Now, just like before, the respondent is going to be served with this petition for renewal and given a court date to show up and fight about it. And so it looks a lot like the original process, except now there's a much bigger advantage for the petitioner based upon what the law is. So the petitioners went into the court, they've asked to renew it, the respondent's been served with the renewal request, and now there's a court date that the respondent has to go to if they want to fight the renewal or extension of the order for a longer period of time. So number 2, what are the standards? What does the law say, and why is it harder? Well, the law says that basically the order shall be renewed unless the petitioner, not the petitioner, but the respondent proves by a preponderance of the evidence that the acts complained of aren't likely to reoccur. And let's just use domestic violence. That's the most common one. That the respondent proves by preponderance of the evidence, that means it's more likely than not, that the acts of domestic violence will not reoccur if the order is terminated. Well, that's a mouthful, isn't it? So basically, the respondent has to show if the court fails to renew the order and lets the order expire, that the acts of domestic violence or the acts of harassment, whatever it might be, won't reoccur. And that's a tall order because the burden of proof is on the respondent. How do you prove a negative? And so the large majority of these orders will get renewed, and they'll especially get renewed because attorneys and unrepresented people defend these totally wrong, in our opinion. So on to number 3. What are the things to avoid, and what are some of the ways to give you a chance to actually win if you're the respondent and show that the order should not be renewed? Well, what's the biggest mistake? The biggest mistake is the respondent wants to relitigate the original finding. Let's say it's a domestic violence case, and a year ago, the court found that the petitioner was a victim of domestic violence at the hands of you, the respondent, and you're still upset about that, which makes sense. And so you go into this court about the renewal and say, I haven't talked to this person in a year, and by the way, I was never guilty to begin with. Here's all the reasons, X, Y, Z, X, Y, Z. Here's all the reasons why the court got it wrong the first time. I never got convicted, or there was no injuries, or whatever. And we have to remember that's not the issue at this hearing. And whenever we're trying to convince someone of something, we have to put ourselves in the position of the decider, in this case, the judge or the commissioner. They have a big calendar. They have a bunch of things they need to get to. And because that's not the legal issue, whether or not stuff happened in the past, if you just go into that, they're just going to tune you out. Boom, auto renewal, because you haven't even gotten to the issue about whether or not the acts of domestic violence are likely to reoccur if the order is lifted. And so it happens again and again. It happens with attorneys. I just saw it happen last week in the court hearing we were at, and it's totally, in our opinion, the wrong approach. So what is the right approach in our opinion? The right approach is to focus on what's changed for the respondent, the person that the order is against. Have you done any treatment? Have you done any counseling? Have you made any changes in your life? Do we have any proof of that? Again, we have to show not that we're a good guy or that nothing happened in the past. That's not the issue. We have to show that nothing will happen in the future. We have to prove it. And the only way a court will, in our opinion, really find that is if you've done something affirmative. Because just saying, hey, there's been no violations of the order, you might think that's enough. It's not. That's always the case, right? If there's been a violation of the order, you've been arrested and you got nothing to say. Okay, so if you haven't done anything, start doing something to give you a chance. And if you have done something like counseling or alcohol treatment or you name it, domestic violence treatment, start getting proof of that together. You're going to need to file that with the court. Also, you can get some character references. How have you been acting for the last year? What's one thing you could tell the court is the petitioner has no idea how I'm different today because I've had no contact with the petitioner. That could be a powerful argument. So those are some of the things you want to try to do. The most important thing to do is get an attorney right away. These are very difficult to win, nearly impossible without an attorney and difficult with an attorney. I think with the approach that I'm describing, you have a reasonable shot. Your attorney has a reasonable shot if they take that approach. You relitigate in the past, really a terrible idea. So I hope you find this video useful. If you're in this situation, someone's trying to renew an order against you, feel free to give my office a call. We've been dealing with this for more than 20 years. We have 5 attorneys. We're well equipped to handle it. And we're only going to try to take your case if we think we have a chance. And if you just are finding this useful, please like the video. Please subscribe to the channel. It will help us get this information out there. So again, if you need any help, give us a call. We'll do everything we can, and we'll be there for you. Thank you.